If you're thinking about filing bankruptcy, you might be wondering, can I transfer my car, my money, or some other valuable property to a friend or family member before I file? Today, I'm breaking down how bankruptcy treats transfers to friends or relatives and exactly how the process works. Hi, I'm Michael Brower, a staff attorney at the law offices of Lee M. Perlman. Before we talk about how transfers might affect your bankruptcy, I want to remind you that talking to a bankruptcy attorney does not mean that you're filing for bankruptcy. It means that you're trying to understand your options and the best path forward to a financial fresh start. If you find this video helpful, I want to remind you to like and subscribe to this channel and contact our office with your specific questions. Bankruptcy trustees pay very close attention to any transfers of valuable assets made prior to filing. Any property transfer within the 2 years before filing must be disclosed in your bankruptcy paperwork, including gifts, sales, or title transfers. Disclosures must include things like signing a car over to a relative, putting money in somebody else's bank account, gifting valuable assets, or moving any asset into someone else's name. During your bankruptcy, a bankruptcy trustee will ask you specifically about any transfers you made prior to filing for bankruptcy. You'll be under oath, so you have to answer truthfully. The trustee is also going to verify your statements by reviewing your financial records. The trustee has powers to undo or avoid specific transfers to get that property back. Fundamentally, this promotes fairness for creditors who might otherwise not get any payment toward their debt. Trustees can undo transactions if the transfer was fraudulent, if the transfer is for less than fair market value. If the transfer was fraudulent, this means you intended to hide or protect the asset from creditors when you made the transfer. For example, transferring money from your account to make it look like you have no assets. If the transfer is for less than fair market value, even if you didn't mean to hide anything, transactions that give away valuable property or sales at below the fair market value of property can still be reversed. Anything the trustee recovers would be distributed to your creditors. In Chapter 7, a trustee recovering a transfer can sue the recipient for money, demand a return of the property, or otherwise try to get value in terms of money back for the benefit of creditors. In Chapter 13, the transfer might impact how much you have to pay through your Chapter 13 repayment plan to benefit your creditors instead. Transfers to relatives get special attention from bankruptcy trustees because relatives are insiders, and they're worried that somebody inside your friend or family group would be easier to collaborate with in order to hide assets from creditors. These transactions can also be undone. This includes paying back a family loan within 1 year of filing, otherwise called a preference payment, gifting or transferring assets for less than their worth, or moving property into a family member's name before filing. If you fail to disclose a transfer that you made before filing for bankruptcy, you could lose your discharge. You could also face fines or prison time. This is serious stuff. Even innocent mistakes can cause delays, additional attorney's fees, or lawsuits for the person who received the asset from you. Transferring assets before bankruptcy rarely fixes the problem. Usually, it just makes the problem worse. There are planning techniques such as using the correct bankruptcy exemptions or choosing the right chapter of bankruptcy that are much more effective at protecting your assets. For example, in Chapter 13 bankruptcy, you keep all of your assets. Instead, you participate in a payment plan that pays back your creditors over time. In Chapter 7, a bankruptcy attorney can help you choose the right exemption scheme, maybe state or federal, that protects the most assets so that you don't lose things that you want to keep. So, how does bankruptcy law treat transfers to friends or family? Of course, the Bankruptcy Code treats these transactions as suspicious, first and foremost. Before making any transfers of assets, consult with a bankruptcy attorney to understand how that might impact your case. I'm Michael Brower, a New Jersey bankruptcy attorney. If you're worried about protecting your assets, or maybe you've already made a transfer, reach out today. Remember, contacting a bankruptcy attorney does not mean that you're filing for bankruptcy. It means you're trying to understand your options so you can find the best path to a financial fresh start. Thanks for watching, and remember to subscribe for more information about how bankruptcy works in New Jersey.